the glimpse of the theories and philosophies as we examine the evolution of environmental law to really give an indication as to how different kinds of thinking and influences have contributed to the very source or the roots of the very development of this body of law called as environmental law. The influences are quite varied, swinging from one extreme of conservation for conservation's sake and environment for environment's sake to environment as just an unnecessary impediment in the process of development, and as long as it is to promote human interest, environment can go along with development, otherwise it has to be discarded. The dominant view of what is called as the standard view. And then you have the other kinds of approach, which is focusing on certain aspects of environment, on certain kinds of life forms, on ecosystems. All these are very rich contributions at some point of time or the other in the course of the evolution of environmental law the world over have had a deep impact on the making of any particular kind of law in that regard. Like, for example, in the case of the Convention on International Trade in Endangered Species, you have a combination of the deep ecological movement, the contribution of conservationists, of the ecosystem conservationist, someone who is interested in ecological modernization, or some of those who are the proponents of biocentric approach, and also, of course, those who would like to facilitate an honest, sincere, environment friendly business interest in relation to the wildlife. All these have actually influenced the shaping of that particular body of law. So is the case with so many other laws. The basic objective behind introducing the student to these kinds of streams of philosophical and thinking about environment is essentially to impress upon them that these are the roots from which environmental law has sprung up. As we turn to the real sources of environmental law in terms of very hard crystallized set of ideas which have the force of law, having contributed to not only its development and evolution, but essentially to the very content of this law. As we get into that, we are struck by a fact that India, a country of composite culture, has had varied influences that have decorated and enriched the very content and the trajectories of development with regard to environmental law as we have now. Let us have a quick look at that. We already know that as being the oldest living civilization on earth, India boasts of such very rich cultural and traditional roots and practices concerning environment, environmentalism, conservation, protection, and management of different aspects of environment. We also know, having been a colony of the British, as we saw just a while back, the dense influence of the common law and criminal law traditions of the British contributing to the early stage of evolution of Indian environmental law. We also do know that with regard to the development of natural resource management law in India, even to this day, whatever that was actually developed during the British time continue to operate with regard to water, with regard to land, as regards forests, wildlife, and things like that, with a few cosmetic touches made here and there as to make it a little bit current and keeping pace with the changing times. But more specifically, in modern times, If you really look at the evolution of environmental law, not just of India, but all over the world, it is these international inspirations at the global level, at the regional level, and the comparative law from different legal systems do have a very deep and abiding influence on domestic laws in different legal systems, including in India. And so it's most appropriate that we need to really focus primarily on these developments, which are fairly recent, of a little around 50 years' time. And that's what we presently do. But before we do that, we also need to really acknowledge the contribution of social movements which had the human rights protection as the main theme, on which the entire claims and entitlements of individuals and communities of people were canvassed, argued for, and lobbied about in various fora, gave way over a period of time to environmental movements. And so the environmental movements in India, as we would see, have its genesis in human rights movement, about which we have already discussed, on which the environmental concerns rode piggyback. And this actually led to the public interest litigations, PIL for short, leading to landmark judgments given by the courts of law, which have further contributed to the jurisprudence on environment. The deep and abiding influence of the courts of law, something which is a standout feature of Indian environmental law, as I did mention earlier. The environmental concern, as the underlying theme of all judicial pronouncements that we have on the subject, is considered as something which is an integral aspect of a public interest concern. And so, the courts of law profusely employed one of those weapons that they had, exercise of the writ jurisdiction, in their adjudicatory processes for securing environmental justice. We will have a separate module in which we will be examining in greater detail and depth about how the courts of law have contributed richly to the development of environmental law in India. But for the time being, it is just to know that these are the various streams that have contributed to the making of what we have as Indian environmental law. And now we will go to a little bit more detailed discussion on the evolution at the international level, which have substantially, right from around 1970, been made the greatest, have had a greatest impact on the Indian environmental law. To learn about this international and regional developments, it is very easy to understand how the trajectories of development of and evolution of environmental law took place over a period of time in the last 50 years. We needed to focus on three major peaks of development in the form of environmental summits or environmental international conferences. That's why they are called as summits. At the apex level, when the leaders of different countries come together, deliberate over environmental issues, and then come to a consensus as to what they should do domestically and in relation to the other nations concerning the environment, setting out an agenda, a work plan to take it back to their countries and to work them and come back and periodically exchange notes and further develop it. That has been the evolution. That has been the way in which the entire body of international environmental law evolved over a period of time. And so, primarily, I'll be focusing on three major international environmental summits that took place between 1972 to 2002 and thereafter. The first one was the Stockholm Summit on Human Environment that took place in the year 1972. How did that happen? Well, it started very late in 1960s in groups and groups of discussions that they had within the United Nations in different quarters expressing serious concern about the environmental degradation that has been caused by human activities and a kind of a realization that over a period of time the human interventions in relation to environment has very drastically affected environmental quality, environmental integrity, leading to the loss of very many species of plants and animals, reduction of the forest cover, contamination of the air, contamination of water, and what have you. And so a kind of a need was raised on UN fora, United Nations fora, that there has to be some kind of a congregation of the leaders of the world to come together to deliberate about this kind of a problem, because if the problems exacerbate and when they become so acute, there is no question of going back, for the simple reason that we have only one earth to live. And so to save the earth, they need to sit, deliberate, and find solutions. The summit that took place in Stockholm in the year 1972 is the first of its kind. Very interestingly titled as the Stockholm Summit on Human Environment, almost like an interface between the human beings and environment and the resultant impact on the environment. It was virtually a global stock taking of the environmental crisis that we had gotten into. All the heads of states, major civilized countries as they claim, including India, were part of the deliberations here. And what was the takeaway of this particular summit? There were three major outcomes of this. The first one was what was referred to as the Stockholm Declaration. It laid down as many as 26 principles, the fundamental principles as to how to manage environment. The crystallized wisdom encapsulated in 26 principles, some of which we will be reflecting on a little later. A second one, a kind of an action plan for human environment. What we should do after we go back after this conference. Is there anything that we are going to carry with us back home? Can we have a kind of an action plan? Yes, it was stated that yes, you have an action plan. And the major feature of this action plan is that having expressed the global concern that environment is deteriorating at such an accelerated rate, the first and the foremost requirement is to arrest the trend. The second one is, having arrested the trend, we need to really work towards maintaining stability and balance. And third, to do everything possible internally and internationally to see that the crisis will not reoccur and further torment humanity. And what was exactly the nature of this action plan? Well, we have laid down the ground principles of environmental governance. That's what we have supplied to you at the international level. Now, as an action plan, you need to go back to the drawing board, to your respective countries. In line with these framework that has been laid down under these principles, fashion out your own set of laws and work them in your domestic legal system. While we think globally, environmental governance and environmental management and improvement of the environmental quality is not possible unless and until we do not really act at the national level, at the local level. So the catchphrase was think globally and act locally. Is that all? No. Having done that, for 10 years you work it. And after 10 years, we will come back and take stock of what we have done in the last 20 years. And then see whether there has been any improvement from the current crisis situation that we are right now in. And then look for the way forward and work it out when we meet after about a decade. The third outcome of this Stockholm conference was to facilitate all these activities at the national level, at the local level, at the international level. A program was envisaged entitled United Nations Environment Program, UNEP for short. And what is the job of this UNEP? UNEP would act as a kind of a think tank, a brain trust, a technological expert group. And those who are there in that will be able to help each and every nation which seeks its help in whatever possible way, either in making of the law or in making those laws work, even in preparing draft bills for consideration by the respective parliaments and for enactment of them as legislations at the parliamentary level, and to organize either regional or global conferences on different sectors of environment and help them through that process develop both a robust international environmental law and a domestic international law that is effective, workable, and working. Well, that was how the Stockholm Conference ended. Those were the very early days of evolution of environmental law, very nascent and effervescent. People were very keen that something needed to be done. There was a clear political will on the part of the leaders among the nations, and so they came back to their respective countries and they started thinking about ways and means whereby those principles are put to work in the respective legal systems, legislatively, administratively, and at the ground level. That is the first part of the development at the global level, 1972 Stockholm Summit on Human Environment. As you could see on the screen, a lot of developments took place between 1972 to 1992. There was already a mention that was made that after 10 years these nations would meet. But as a matter of fact, between 1972 to 1982, when so many developments took place, the community of nations felt that whatever they had done that for was not adequate, was not sufficient enough for them to meet again in a global summit of that dimension, of the Stockholm kind. And so they felt that they should work this for another 10 years and then in 1992 come back, take stock and move forward. And so between 1972 to 1992, no international global environmental summit of the kind that took place in Stockholm did happen. But there were so many other activities under the aegis of and with the help of the UNEP. A number of activities took place, and I have just mentioned some three of them here. A host of global conferences on specific areas of human activity. There were population conferences, there were conferences on habitat, there were conferences on water, like that, on so many resources, on so many aspects of impacts on environment by human activities, and that also led to evolution of certain concrete international environmental legal arrangements. They are referred to as conventions. There was a major convention on heritage, cultural and natural heritage conservation, the same year in 1972. Then there was this convention on international trade on endangered species, CITES for short, that took place in the year 1973. There was a conference and a treaty of protecting the ozone layer, the convention, the United Nations Convention on the Protection of Ozone Layer, 1985 and 1987. 1987 was a protocol called the Montreal Protocol on Protection of the Ozone Layer. And then in the year 1989, the focus of attention of the international community was on managing hazardous substances. Hazardous substances that are of international nature, something that was generated in one particular country being dumped in another as something unfair, unjust, iniquitous, and something which would actually affect the environment of something that was produced in one country being passed on to the other. And so another convention took place wherein a large number of countries came together, agreed upon a set of rules and regulations that when there is going to be a transboundary movement of hazardous substances, movement across nations, generated in one country, transited through another country, and being disposed of or dumped in yet another country, what kind of safeguards, what kind of protective measures, what kind of care that need to be taken to ensure that even when this kind of an activity takes place in a regulated way, harm is minimized or even eliminated. It's also called as the Basel Convention on the Transboundary Movement of Hazardous Substances. The year was 1989. The third development, major one, that took place between 1972 to 1992 was something that happened in the mid 1980s. The realization was, while all these efforts of conferences and conventions converging to achieve one particular goal of a better environment globally, there were misgivings. There were misgivings on the part of the developing countries. The misgivings were in the form of a concern that when we are attempting to improve the quality of environment, arresting the trend of destructive development, will it not in any way affect our need for, our right for development? Because it was a very well recognized international rule of law endorsed in the United Nations that every individual, every community of people, every nation has a right to develop. It's a human right. So, right to development as a right, a human right. Will that not get affected? If this development is stunted by or put to brakes by an environmental conditionality. And so the developing countries were developing a bit of a cold feet to pursue further this environmental agenda, environmental conservation and protection agenda. On the other hand, the developed countries, having had a bit of a saturation of development, economic development at that, having contributed very heavily to the destruction of the global environmental quality in a wide variety of ways, they were very keen that development of this kind we should put an end to. We should get into more responsible developmental agenda, and that is possible only when we protect the environment. And so there was a bit of a conflict of these kinds of ideas, and this political interplay that took place amongst the developing and the developed world was actually contributing to less than required attention being paid to environmental protection. The well-meaning leaders among the nations, they felt and experienced this danger that if we allow this kind of a conflict between developed world and the developing world to escalate any further, then environment would further be a casualty in the process, and we will leave nothing for the future generations to really fall back upon for their survival and sustenance, let alone development. And so they constituted a high powered committee under the leadership of the former head of Norway by name Gro Brundtland. And this committee was charged with the task of coming up with a formula, coming up with a report, which would at once satisfy both the developing nations and the developed nations and move the environmental agenda forward. It was a very monumental step, clearing off the cobwebs of doubt and suspicion that one group had about the kind of inclinations of the other, whether it would come in the way of our development. And the other group pursuing this particular thing were very keen that they wanted to, so that their leadership with regard to development would remain unaffected. So pursuing these kinds of agenda, there has to be some kind of a meeting point, and for which this particular committee engaged itself for well over 3-4 years to ultimately come up with a report in the year 1989 entitled Our Common Future. A wonderful work, very highly researched work, which has a combination of contributions coming from development gurus, environmental experts, environmental economists, political leaders. A kind of a churning took place leading to this particular report. And in that report, they came up with something called as a magic wand, called as the principle of sustainable development, that we will facilitate if we properly plan and execute a global environmental agenda whereby we will promote development, at the same time we will also protect environment, and we call it as sustainable development that can sustain in an environmentally benign way. Satisfied with the outcome of this particular effort, the stage was set for the global leaders to meet again 2 decades after they met, and that was the year 1992. And in 1992, when the global leaders met in a place called Rio de Janeiro, and so this global environmental summit was called as the Rio Summit, and it was given a very catchy phrase of a title: Rio Conference on Environment and Development. If the conference in Stockholm was the conference on human environment, the Rio conference was on the meeting ground for environment and development, and so aptly titled as an Environment and Development Earth Summit. It was perhaps the first major global summit, much more than the Stockholm summit, which had the widest subscription of participation from a wide variety of groups. While at Stockholm, only the heads of states met. In this global summit that took place in 1992, not only the heads of states met, scientists had a lot of contributions to make. Scientific experts groups were there, developmental leaders were there. There was a representation that was given to voluntary groups in the form of NGOs. All these came together. There are several parallel sessions And ultimately, they came up with a number of outcomes. And these could be summarized under four heads. The first one was the Rio Declaration on Environment and Development. Very similar to the Stockholm Declaration, which produced a host of principles. Rio Declaration, after having taken stock of the developments in these 2 decades and to tighten the screws of action not adequate, inaction, and so to galvanize into action, came up with 27 robust principles of environmental governance. The second one was to effectuate or bring into application these 27 principles. Stating principles is not sufficient, how to work it. And for that, the second outcome was very aptly titled as Agenda 21. It was an action plan for the century and the millennium that was coming to an end. The year was 1992, and the millennium is going to end in another 8-9 years. And so, in the next 8 years, what the global community of nations should do locally, nationally, and transnationally. And for that, an agenda was set. A huge document on every conceivable aspect of environment. An action plan was set for the realization of goals set on each of these sectors under this summit, and that is to be accomplished in less than 10 years' time. Remember that this global summit should take place in 2002, 10 years from now, and we should be able to give a better account of ourselves. And so, in 10 years' time, on each of these sectors of environment, we will work on that, we will set these goals and achieve them, and we will give a better account of ourselves. This Agenda 21 comprised of 40 chapters of actions, action points, to be taken back by the respective countries and worked in their legal system and reported back in about 10 years' time. The third outcome, they were very much concerned about the fast depletion of the very rich natural resource in the form of forests all over the world. But forests are there in the domestic jurisdiction of states. So each and every state had a complete sovereign authority over the resources. And so international arrangement should not interfere in the internal affairs of the governance of their natural resources. But setting out a principle for guidance, there is no problem. And so the third outcome of this particular summit was to set a non-legally binding but very authoritative statement of principles, which is actually a global agreement or a consensus on conservation, management, and sustainable development of forests. And so, you already have your own respective forest laws in your country. Please check that. Please check that law, whether it would come in consonance with the set of principles that we have given for a better management of your forest, for better conservation and development of your forest. And for that, we are giving you a set of guidelines and principles. That is the third outcome. The fourth outcome is the far more significant outcome of this Rio conference, and that is two important major international agreements. Agreements is the crystallized law for action. Unlike the first three, one was a declaration, the second one was an agenda for action, and the third one was a set of authoritative principles. These principles and action points are not something which is going to be put into action unless and until you have a robust law to back it up. And those laws were evolved in two different sectors of common global concern of community of nations. One was on climate change, entitled United Nations Framework Convention on Climate Change, and second, the Convention on Biological Diversity. Remember that these two are major international legal developments which had the subscription of almost all the countries of the world. If you have about some 200 countries, around 190 odd countries became parties to this, which is the other way of saying that this is a binding international obligation that each and every nation should respect, should honor, commit, and comply and report back at the global level. So these are the four major developments that took place at the international level in the second major international environmental summit that took place in Rio de Janeiro. Then what happened? 10 years of development between 1992 to 2002. The leaders of the world felt that having come up with these four major action points, that is not sufficient, that we should create one more institutional arrangement which will be able to work this. Remember what we did in 1972. We came up with the United Nations Environment Program. Now we will come up with a Commission on Sustainable Development. It is not just a principle on paper, but a principle to be worked in every sphere of human activity, and to oversee that we will set up a commission. And the job of this commission is to see to it that the ethic of sustainable development is brought into application in every sector of environmental management all over the world. Alongside this commission, in order to provide the required finances for the developing countries, and also to provide the technical assistance for these countries to work on climate change, to work on conservation of biological diversity, a kind of a fund was created, a fund and a facility for pooling of an environmental fund, an environmental facility, a pool of talent and skills and technologies were pulled together for making it available as and when required to give effect to the obligations under climate change and the obligations under the international arrangement concerning biological diversity. It was called as the Global Environmental Facility or Fund, and this has to be worked through the World Bank as the international financial institution. Through that, we will make available this particular arrangement, that not only we create law, not only we create international prescriptions of code of conduct for observance by nations, we will also help and assist you in reaching your goal with a kind of funding, with a kind of technological assistance that is required. And whenever these developing countries require that, under certain conditions, these will be made available. A couple of other developments took place. That increasing desertification was also a global concern, and so there was another international convention or an international treaty arrangement called the Convention to Combat Desertification, took place in the year 1994, and to make sure that all the nations are clued in giving effect to what they had committed in Rio de Janeiro. Within 5 years, there was an interim arrangement of a meeting in Singapore called Rio Plus 5. 5 years after Rio de Janeiro summit, we will sit and some of the leaders would sit and then examine what we have been doing all these 5 years. Is the progress good? And if it is not so, how to really step it up, how to really scale it up. That's what we shall do. This was done in the year 1997. This also led to another major international development with regard to climate change. We only have developed a framework convention, but to operationalize that framework convention on climate change, we needed to have a protocol. And so, a protocol of a mechanism for working the climate change arrangement that took place in the year 1997 in a place called Kyoto in Japan. And so it was called as the Kyoto Protocol on Climate Change in 1997. And then to work the Biodiversity Convention, another protocol. A protocol was in the year 2000 to take care of the issue of biosafety. It's called the Cartagena Protocol on Biosafety in 2000. The same year, the United Nations prepared a set of goals for development. They were called as Millennium Goals for Development, and environmental development was one among the many agenda that was prepared for the international community to achieve in the next decades to come. So 2 years hence, so 2 years hence, subsequent to the UN Millennium Development Goals for Development unveiled, we have the third International Environmental Summit taking place in Johannesburg in the year 2002. And the catchphrase for this Earth Summit was the Sustainable Development Summit. The Summit on Human Environment in 72, Environment and Development in 1992, Sustainable Development Summit in 2002. Look at the development of the three major international events over 3 decades' time. From 1972 to 2002, we have moved on to an arrangement of nations coming together with a single goal of ensuring sustainable development. It too had a large number of participation, and for the first time, the leaders of the business were invited and took a very active part in the deliberations, quite unlike the Stockholm Summit and also the Rio Summit, wherein industry was not something that was part of this particular conclave that took place in those two summits. In Johannesburg, their presence was very, very densely experienced. That they were also called in. The earlier feeling that the leaders among the nations felt that industry is the greatest polluter, industry is the one who is the enemy to environment, and so we should keep them off and we should really deliberate. And they found the futility of that particular exercise, that we did so many things, but we have not been able to discipline the industry. And through that, we have not been able to discipline ourselves. And so there is no point in keeping them out. We also bring them in and hear their points of view and further work it out as to how well we can have a better world with a better environment. And so 2002, we have another major player in international affairs getting into a global environmental summit, the Global Summit on Sustainable Development. In terms of what actually happened in the summit, which is far more detailed and elaborate, one need not have to go into it. Suffice it to say that quite unlike the environmental summits in 1972 and 1992, the approach now became a little bit more pragmatic.